We're not going to convert you into lawyers today. We're not going to make you experts in securities and the securitization of loans. What we are going to do is we're going to teach you the basic language and the basic concepts that are important so that if you have to go to court alone, if you are interviewing an attorney, you'll know in a very short period of time whether the attorney, or the judge for that matter, understands a word that you're talking about. More and more lawyers across the country are starting to pick up on the various defenses that we raised. Well, I raised initially 2 years ago when I started the blog, livinglies.wordpress.com, and that we started promoting in a year ago. And what you're going to find here is that there are certain things that you can focus on and that will help you understand what happened with your loan. And once you understand it, you're going, for those of you who are not alumni, you're going to find yourself angrier than you are right now. Because what happened with your loan, assuming it was securitized, which almost all of them were, what happened with your loan was incredible, outrageous, and created profits that are unimaginable by any standard. Things you should know. You can win. That means keep your house. It's more difficult in California right now, procedurally, with the judges who are uncooperative to achieve this result, because you have a dichotomy between the lower jurisdiction court and the higher jurisdiction court, and the pretender lenders and their attorneys are playing games with getting around what we call due process and using the unlawful detainer in order to seal the deal. We're going to show you some things that you can do that will assist you, specifically in California, in that fight. There are no guarantees here as to your results. What I'm giving you here is the result of 2 years of research on this particular topic alone. I have done nothing else. And some 40 years of working with securities and deals and being a trial lawyer and a variety of other related careers. The rules here are simple. There are no rules. If you've got a question, then ask it. I may shorten your question, and I may give you a short answer because I don't want to shortchange everyone else. But you are free to interrupt me, challenge me. You can start off with "but." It's okay. I won't be offended. Second thing, very important. Most people who get into the situation where they're at a seminar like this, how many of you are currently in litigation now? Okay. How many of you have received a notice of default but you're not yet in litigation? All right. You probably would assume, because this is the way it used to be, that if you didn't make a scheduled monthly payment, that your loan was in default. So you're assuming right from the get-go that when you get a notice of default, they're right and you're wrong. In the world of securitized loans, that is not true. But they're making it true because everybody is assuming that it's true. The person or party that sent you that notice of default probably has no idea whether the true lender in your case was paid through federal bailout or insurance or whatever. You'll hear lawyers on the other side say, and other people say to you, well, you didn't make the payment due, and so you're in default. Well, the answer is, was it due? And, by the way, who was it due to? You will find in the course of the seminar that the people who actually lent you the money are people you never heard of. You will find that in many cases, if not most, they have been paid in whole or in part through federal bailouts and insurance. You will find that that the worse the loan, the more toxic the loan, the more money they made. What does that mean? It means that the more likely it was for that loan to fail, eventually, the more money they made. They turned everything upside down, and I'm going to show you exactly how they did it with actual dollar numbers and so forth. So it may well be that at the time of your closing, legally, the note was paid, and therefore the mortgage never attached as an encumbrance, the deed of trust. The obligation is something else. Now, this sounds like splitting hairs, and it is. We never had to split these hairs. Even in law school, we didn't have to split these hairs until the securitization of loans. But it is entirely possible that the note was paid at any number of steps in the securitization process, all the way up to the pension fund, the hedge fund, or sovereign wealth fund that bought the pool of loans that your loan was put into. I already made reference to the fact that it's getting complicated out there. Beware of mortgage rescue firms and even lawyers who are setting themselves up as, associated with the mortgage rescue process, unless they can show that they have actual experience and knowledge in the things that we're going to talk about today. Avoid them like the plague. The stories that I keep getting are, they took my money, I paid $12,000, nothing happened, etc. That's not to say that all firms and all lawyers are crooks. But you need to interview people in the same way that you'd interview somebody to cut your lawn or anything else, or as an accountant. Satisfy yourself that these people know what they're doing. Get references.